After having participated in 7 parliamentary sittings, we do have the privilege to welcome the Honorable Osei Kyei-Mensah-Bonsu, who is head of government business, to come and give us a perspective of the legislator as far as constitutional review is concerned. What timing? Great timing. Because there are several things that are happening around us as a country, and since we are not an island, these happenings do have ripples and ramifications as far as our global existence is concerned. And so as a university, we are delighted that we can participate in these public lectures, ensuring that we do not only participate, but we also set the agenda so that the developmental trajectory of this country would be adhered to. I still recall that one of the recommendations that the erstwhile Presidential Commission made was on the independence of the National Planning Commission, something which has been upheld to date. And I'm hoping that with the repertoire of experience that the Honorable Minister does have, he will espouse and open our eyes to what the legislator's perspective would be as far as constitutional review is concerned. And so on behalf of the management of this university, I welcome all of you, and I do wish you a wonderful time of listening and participating in this public lecture series. Soon afterwards, there will be a group photograph session, and then the Vice-Chancellor will host you at the Great Hall foyer to a small reception. I welcome you, and thank you for your kind attention. Thank you very much.
Towards an ethical outlook on life. Without such an outlook, or if it is insecure here, civilization decays, and we will be left without a moral leg to stand on. But unlike so many writers who reach similarly brutal conclusions, Dr. Weiser is ready to build afresh on his famous principle of reverence for life, the positive philosophy which will be the problems of today. This idealism demands that each individual should have a responsibility without a need to call others. The song for nation building.
How's that?
Now to the most important moment of this gathering, and that is the delivery of the lecture. But that will be done after a comprehensive introduction of our speakers for today. The chairman for the KNUST Public Lecture Committee is Professor Atinoke Ozusola Adebanji. In her stead, the acting chairman will introduce our distinguished speaker. Ladies and gentlemen, a round of applause for Dr. James Crawford.
Thank you very much, moderator. Honorable Osei Kyei-Mensah-Bonsu was born on February 3rd, 1957, in Kumasi, the hills from Afrantu in the Ashanti region of Ghana. He was educated at St. Secondary School in Kwetiakwewu, where he sat for both the ordinary and advanced level examinations, and then proceeded to the University of Ghana to read LLB. He later changed school to the University of Science and Technology, now Kwame Nkrumah University of Science and Technology, where he obtained a BSc degree in urban planning. It was in secondary school that he had a baptism into student politics. He joined the student movement for African unity and rose to become vice president for the movement. At KNUST, he became the president and at the same time joined the Pan-African Youth Movement. He was twice the president of the Junior Common Room of the University Hall and president of the Students' Representative Council, SRC, whilst he was in the university. He started work as a national service personnel at the Kumasi Girls Secondary School, where he stayed on to become a substantive teacher. He then moved to South Africa, where he was the project manager of Datamin Consort, which operated in Zimbabwe and Zambia. From then on, he was self-employed, trading in vehicle spare parts in the famous Swami magazine until he entered political office. Since becoming a member of parliament,
He has taken leadership positions as Secretary to the Majority Caucus, Deputy Majority Whip, Majority Chief Whip, Deputy Majority Leader, Minister of State, Parliamentary Affairs, Minority Leader, Majority Leader, Minister of Parliamentary Affairs, and Leader of Government Business. He has also been the Chairman of the Special Budget Committee for the Advisory Board on Water Restructuring, Director of the Cocoa Processing Company, Leader of Ghana's Parliamentary Delegation to ECOWAS Community Parliament, Leader of the ECOWAS Fact-Finding Mission to Ghana, La Côte d'Ivoire, and Burkina Faso on the conflict in La Côte d'Ivoire, Leader of ECOWAS Community Parliament Election Monitoring Delegation to Liberia, Leader of the ECOWAS Community Parliament Election Monitoring Delegation to Nigeria, Chairman of the Committee on Democracy and Human Rights of the Interparliamentary Union, Chairman of the African Parliamentary Network Against Corruption, Ghana Chapter, Chairman of the African Parliamentary Network Against Corruption, Africa Region, and the Vice President of the Global Organization of Parliamentarians Against Corruption. In terms of his service on committees of Parliament, he has served as a member, ranking member, and vice chairman, and the chairman of the Business Committee, vice chairman and ranking member of the Appointments Committee, and vice chairman of the Special Budget Committee. He has also served on the committees on Selection Works and Housing, Youth and Sports, Lands and Forestry, Subsidiary Legislation, and Standing Orders. Honorable Osei Kyei-Mensah-Bonsu has been part of several parliamentary delegations within and outside Ghana during his term in Parliament. Some of these delegations have been to meetings and activities organized by the Commonwealth Parliamentary Association, Inter-Parliamentary Union, African Parliamentarians Network Against Corruption, Global Organization of Parliamentarians Against Corruption, National Council of State Legislators, and the ECOWAS Parliament. In 2017, Leader, as he affectionately called by many, received double honors from chiefs and queen mothers of Swami constituency under the auspices of Otumfuo and the University of Professional Studies, UPSA. He was installed as the Sompahene of Swami constituency and also honored with a doctorate degree, honoris causa, from UPSA. He is currently the 7th term NP for Swami, Honorable Minister for Parliamentary Affairs, the Majority Leader, Leader of Government Business, Leader of the House, and was a minister with temporary responsibility for the Ministry of Finance. In 2001, he was elected the Vice Chairman of the Commonwealth Parliamentary Association. On this note, ladies and gentlemen, it is with great honor I invite Honorable Osei Kyei-Mensah-Bonsu, Minister for Parliamentary Affairs, Majority Leader, and Leader of Government Business to deliver the lecture. A round of applause.
Thank you very much, Professor, for such introduction. I hope I'll be able to live up to the introduction that you have made and that the presentation doesn't suffer any anticlimax. Professor Chairman, Pro-Vice-Chancellor, KNUST, Professor Elise Usu-Dabo, the Registrar, Mr. Andrew Kwesi-Boateng, Provosts, Directors, Registrars, Deans, Heads of Departments, Nananom, Nanahima, the new Patriotic Party executives, GRASAC President and his executives, the Public Lectures Committee members, the SRC President and his executives, the Speaker and members of the Kwame Nkrumah University of Science and Technology Students' Parliament, the media, distinguished ladies and gentlemen, good evening to you all. Professor Chairman, with your indulgence, I would like, with all the timidity, to introduce my roommate and chief whip, Mrs. Irene Kyei-Mensah-Bonsu. In whom I'm sometimes well pleased. Not always, though, I must confess. Her rainfalls in the house are often quite unpredictable. And on such occasions, they pour from cumulus clouds amidst heavy thunder. And on such occasions, the Son of Man has nowhere to lay his head. That often is directed at the children. A few occasions that they are directed at me, God is my provider. When I left the walls of this prestigious institution some 40 years ago, I never for once imagined that I will be standing here in our great hall today to deliver the first lecture by the Public Lecture Committee, that is post-COVID. Mr. Chairman, I believe before I continue, and that is not to remind us of the letters that we wrote in yesteryears, when we would start, the brightness of this day has given me the golden opportunity to pen you this my missive. And then after writing one chapter, he would then intervene before I commence. He has commenced already. But if you say before I commence, I want to know your present condition of health. So before I proceed further, permit me to also acknowledge my colleagues who are here, Dr. Bafo, Asafu Ejei, the Honorable Vitosu Kwekudia, Dr. Professor Ekuoku, and the rest of them. And I thought I saw my colleague, the Honorable Patricia PJ here. I don't know whether it was a ghost that I saw. Professor Chairman, as an alumnus, I have been proudly following the achievements of my alma mater, in particular the recent laurels won by the Kwame Nkrumah University of Science and Technology in the ranking of universities worldwide. Best University in Ghana and West Africa for 3 years running. The 12 best in Africa according to the US News and World Report. Mr. Chairman, I'm wondering if anybody can tell me how Legon ranked in the, and I know my colleagues, some of them who are here, they were there. I don't want to talk about that. Kwame Nkrumah University of Science and Technology has been ranked in May 2022 as, quote, the top university in Africa and 14th globally with a score of 83.7% based on its commitment to Sustainable Development Goal 4, SDG 4, quality education. Kindly accept my sincerest congratulations, and I urge you to continue the good work for God and country. My gratitude and admiration go to the hardworking Public Lecture Committee. Your intuition and sensitivity in the choice of a subject matter which is a permanent issue now is remarkable. I just took a cursory look at the program and noticed that I've been allotted 40 short minutes. Professor Chairman, as I indicated to you, I do not want to believe that this is an examination paper. Notwithstanding, I shall endeavor to score all the goals by full time. However, I do know that Professor Chai would allow me injury time and extra time if needs be. I've been accused oftentimes of being quite loquacious by many, but it is an occupational hazard. I believe ordinarily I'm a man of few words, and I trust sincerely that my wife will attest to that. As a Minister for Parliamentary Affairs, I have since 2017 flagged the need to revisit the 1992 Constitution. The 2022 Annual Action Plan of the Ministry encapsulates this activity as the Minister's priority area under the key issue, deepening democratic governance. This is because, as a practicing parliamentarian of continuous 25 years experience, I believe I have sufficient acquaintance with the 1992 Republican Constitution and therefore properly primed to advocate for a review. I am accused by many that the Constitution is my second Bible. I always carry a hard copy. And why not? It is a living document, and I must share my bed with it in order for the two of us to have an effective relationship. I can talk to it, and it can also talk to me. Professor Chairman, distinguished guests, it has been 3 decades since the 4th Republican Constitution of Ghana was promulgated on the 28th of April 1992. This Constitution has endured and served the nation generally well, having successfully underpinned the 4th Republic, which is the longest democratic dispensation this country has enjoyed since independence. However, there have been numerous appeals for the Constitution to be revisited. Many well-meaning and prominent Ghanaians have made suggestions for the amendment of particular constitutional provisions and even a reconsideration of the suitability of our system of governance. Which frame of government, presidential, Westminster, or hybrid, would facilitate optimum development for a small unitary country such as ours. 3 of our past presidents, President J.J. Rawlings, President J.A. Kufuor, and President J.E.A. Mills, have all at various times spoken about the need to amend aspects of the 1992 Constitution. The current President, Nana Addo Dankwa Akufo-Addo, has also joined the fray of those who have been unambiguous and unequivocal in their advocacy for amendments to the Constitution. They cannot all be wrong. However, just like any other endeavor in life, there are some of our compatriots who are opposed to the idea of a review. Some notable Ghanaians, though in the minority, it seems to me, have expressed the desire to maintain the status quo. And they say to us that if it is not broken, why fix it? They hold a conservative view that the Constitution is satisfactory in its current form. There are yet others who opine that the spirit of the law must guide the conduct of the polity. Ghanaians, rather, they argue, need an overhaul in their values. In other words, something more than a constitutional review, a complete transformation, or, no blasphemy intended, a complete transmogrification, or, to be relevant on the campus of the University of Science, a total transmutation of Ghanaians is required, something more than a constitutional review. It is the reason why it has been said in some quarters that the Constitution has not failed, but rather as a people, we have failed. Now, let me relate to the architecture of the Constitution. My thoughts are simply that the preamble of the Constitution establishes the mission of the Republic when it registers boldly. And I quote, "In the name of the Almighty God, we, the people of Ghana, have established a framework of government to secure for ourselves and posterity the blessings of liberty, equality, opportunity, and prosperity. This we have done on the platform of freedom, justice, probity, and accountability, and based on the principle of universal adult suffrage, the rule of law, the protection and presentation of fundamental human rights, and freedoms, unity, and stability of our nation. The sovereignty of the Ghanaian people and the supremacy of the 1992 Republican Constitution are established by Article 1, Clauses 1 and 2 of the Constitution. Article 3, especially Clause 4, commits the defense of the 1992 Constitution into the hands of all citizens of Ghana, and indeed, unless and until all the citizens of Ghana elect to abandon that responsibility, that right and duty at all times to defend the 1992 Constitution, the 1992 Constitution shall continue to exist and be operational. Articles 1 to 3 constitute Chapter 1 of the 1992 Constitution. Chapter 2 is on the territories or the areas that make up the geographical entity called Ghana. Chapter 3 defines who is a Ghanaian, whereas Chapter 4 covers what the laws of Ghana are. Chapter 5, which comprises clauses 12 to 33, is on fundamental human rights and freedoms and the protection of same rights and freedoms. Chapter 6 provides the mission statement of the state, captured as the directive principles of state policy. It is the policy encapsulation of the overall development plan for the country, expressed as the political objectives, that is in Article 35, economic objectives, Article 36, social objectives, Article 37, educational objectives, 38, cultural objectives, Article 39, international relations objectives, Article 40, and duties of citizens, Article 41. The coalescence of these objectives should be the realization of basic human rights, a healthy economy, the right to work, the right to good health care, the right to education as expressed in Article 34(2). In the event an obligation is imposed by the Constitution on Parliament, the President, the Judiciary, the Council of State, the Cabinet, political parties, as well as other relevant bodies, to be guided by the directive principles of state policy in taking and implementing any policy decisions which will culminate in the establishment of a just, united, free, stable, and prosperous Ghanaian nation underpinned by a transparent and accountable government, as contained in Article 34(1) of the Constitution, and indeed the preamble of the Constitution. Democracy is a representative government, and in recognition of that, citizens are accorded the right to vote, which right is secured via registration for the purposes of public elections and referenda, and that is provided under Article 42. It is therefore strange for some people to rise up, as occurred about 4 years ago in the lead up to 2020 elections, to canvass the idea that every citizen of 18 years must be allowed to vote. Article 43 grants the right to Ghanaian citizens who are 18 years of age or above and of sound mind to vote. But that right can only be exercised after one has registered as a voter. So if you are 40 years of age and you are a Ghanaian and of sound mind, you cannot just simply walk to a polling station to cast your vote unless you have your name in the book of life, which is the voters' register. Now, I guess it's important to talk a bit about the role of political parties. Political parties are vehicles for shaping the political will of the people, to disseminate information, which information itself must be well researched and appropriate, not propaganda, on political ideas, social and economic programs, and sponsor candidates for elections to any public office other than the district or lower local government units. And that is contained in Article 55. That is why the political parties themselves must get it right and themselves be populated by experienced, competent, efficient, and effective persons who can churn out ideas which have the potential of maximizing the rate of socio-economic development to secure maximum welfare, freedom, and happiness of every person in Ghana, and to provide adequate means of livelihood and sustainable employment to the Ghanaian people and public assistance to the needy, as contained in Article 36 of the Constitution. Prof. Chairman, I guess it's important to also relate to the anchor of the Constitution. The anchor of the 1992 Constitution is provided by us. The preamble of the Constitution provides the framework of government which sustainably secures for the citizens of today, tomorrow, and the day after tomorrow the blessings of liberty, equality of opportunity, and prosperity. Now, the principal strands of the anchor are: 1, the executive, the legislature, the judiciary, the Council of State. Besides these, one can also identify other constitutional creatures, that is, the independent governance institutions, such as the Electoral Commission, the Media Commission, the Commission for Human Rights and Administrative Justice, the National Commission for Civic Education, the Public Services, the Armed Forces, the Police Service, the Fire Service, the Auditor General, the Government Association, and many others. Finally, one cannot be unmindful of the role defined for our chiefs under Chapter 22 of the Constitution. We have practiced the 1992 Constitution for close to 30 years now. Are the various strands in place effectively and efficiently functional and contributing to the smooth functioning of the greater whole? Or is it the case that some of the strands are loosening up or exfoliating or even peeling off? Do some of the strands need tightening up or repairing or retrofitting? Professor Chairman, I'll start with the executive. The president that the Constitution has erected in Article 57 is the head of state, the head of government, and commander-in-chief of the Ghana Armed Forces. The executive authority in Ghana vests in the president. That is captured in Article 58. And the executive authority of Ghana extends to the execution and maintenance of the Constitution and all laws made under or continued in force by the 1992 Republican Constitution. Accordingly, all appointments into the public services are at the instance of the president. That is captured in Article 195. And I quote, "The power to appoint persons to hold or to act in an office in the public services shall vest in the president." So all public servants exist at the instance of the president. And sequel to this provision, the president appoints the head of civil service, that is referenced Article 193. In the meantime, there is even a conflict between Article 194(7) and 71(1)(d). The president appoints persons to the Police Council, Article 201(g) and (h). He appoints the IGP, Article 202, Prison Service Council, Article 206, 1 and K, Director General of Prison Service, Article 207, Armed Forces Council, Article 211T, the CDS and Service Chiefs, Article 212, Fire Service, SHRAG, Article 217, Commissioners of NCC, Article 232, Media Commission, 166, Government Association, 185, MMDCs, 243, the governing boards of various bodies and authorities established by various acts of parliament, ambassadors, high commissioners, etc., etc. Indeed, any president appoints more than 5,000 officers into public office. We are still counting. This certainly, Professor Chairman, is a monarch that the Constitution has created. The rest of us citizens hold him in awe, and even when he strays, it is difficult to talk straight to him. This arrangement needs to be revisited. It cannot be good for our growth. It cannot be good for the growth of democracy. The country needs a head of state and government. Therefore, agreeably and understandably, at any given time, we shall have a president or prime minister. However, there is an empirical study conducted by the World Bank which suggests that small unitary countries are better served with prime ministers as heads of state other than presidents. A president has the whole country as his constituency, whereas a prime minister operates from his or her own small cell. When the parliamentary leader wins and his party wins majority of seats in parliament, he becomes the prime minister. His campaign purse is small as compared to the president's campaign wardrobe. Of late, electioneering campaign funds of contestants at every level of political arrangements has been escalating. The campaign funds of parliamentary candidates from primaries to national elections is averaging $600,000. $600,000. That is according to the research conducted by CDD in respect of the events culminating in the 2020 elections. $600,000. If we are converting it to cedis now, it will be 4.8 million Ghana cedis to elect a member of parliament into office. Now, if you elect such a person into office, he or she is not a Father Christmas. You make him a minister. What do you think will happen? And as a nation, we turn around, we say we want to combat corruption. How do you combat corruption when we do this to ourselves? Mr. Chairman, that amount is huge. We are yet to begin the counting of notes in the lead-up to the 2024 elections. The campaign pairs of a presidential candidate from party primaries to the national elections by any proper reckoning and accounting cannot be less than the equivalent of 50 million United States dollars. How much does that translate to? 50 million. Over 400 million. Where do the candidates have the monies from? There is a nexus between huge campaign expenditure and corruption through the award of contracts. What therefore should be our preference pursuant to good governance? As a nation, we must confront this. Do we need this expensive structure of government in the president, or a much lesser evil in the form of a prime minister who is, as well, much more accessible and accountable to the representatives of the people? We have a choice. In a strict presidential system, ministers are appointed from outside parliament. Invariably, they are all technical persons in various fields who, when they come to be appointed, are able to assist the president in the determination of policy of government and also for the efficient running of the state. These are experts, they are consultants, technical people, they are professionals who add value to government. That is what obtains in the United States of America, which is the flagship of presidential systems in the world. In the Westminster system, the Prime Minister appoints ministers for the same purpose in the determination of general policy of government as contained in our Constitution, Article 76(2), and also for the efficient running of the state, Article 78(2). The ministers in the Westminster system are not necessarily technocrats, but they are often long-serving members of parliament who must have served on committees for some time, risen to chair the committees, or perhaps served as shadow ministers and acquainted themselves with all matters pertaining to particular ministries or departments or agencies, such that they might have become authorities in matters concerning the various ministries, departments, and agencies. When such people are appointed as ministers, there is manifest value addition, unlike what obtains in our Fourth Republic, where because of the hybrid system of government that is being operated, the president is compelled to appoint a majority of ministers from parliament, and that is according to Article 78(1), which provides ministers of state, and I'm quoting, shall be appointed by the president with the prior approval of parliament from among members of parliament or persons qualified to be elected as members of parliament, except that the majority of ministers of state shall be appointed from among members of parliament. You are all witnesses to what obtains in such an arrangement. Many ministers, deputy ministers, when they get nominated and who appear before the appointment committee of parliament, when asked fundamental questions, rudimentary questions relating to their designated ministries, would often respond. And I'm quoting them. I don't know, please. You approve of me, and when you do approve of me, when I go there, I shall learn. What are you going to learn? When the Constitution provides that you shall assist the president in running the state efficiently, and the Constitution provides that you shall assist the president to evolve policies for your ministry, you are telling us at the appointment committee that we should approve of you. When you go there, you go and learn. So what value addition are they adding to your governance? Ladies and gentlemen, that's what you have. How are such persons, rudimental learners, going to assist the president in the determination of general policy of the ministries, the superintendent, or indeed of the government? How are they going to help in the efficient running of the state? It is one principal reason why, as a nation, we are marking time. We are stuck because many of our ministers do not add value to our governance. That's the truth. And I'm not here talking about the current MPP administration. I refer to all administrations since 1993. The time has come for us to seriously introspect on this. And hasn't the time come for us to place in the Constitution an upper ceiling on the number of ministers of state that we should have? As I've already stated, cabinet ministers assist the president in the evolution of policies. That is according to Article 76 of the Constitution. All bills and agreements that are presented to Parliament are underpinned by governmental policy and principles, which the cabinet ministers propose to cabinet. So if you are not a cabinet minister, you are not part of the process of the evolution of policy. That means that a minister who is not a cabinet minister cannot assent to or present a bill or agreement to Parliament if that minister is not a cabinet minister, and therefore is not part of the process of the formulation of policy and principle. If that is the case, as I believe it is, why have such huge number of ministers in the first place? Again, it's important for us to do serious introspection on this and interrogate the Constitution. The Constitution provides in Article 76(1) that there shall be a cabinet which shall consist of the president, the vice president, and not less than 10 and not more than 19 ministers of state. And quote, given the role of ministers of state, who cabinet ministers are, that is for running the state efficiently and assisting the president in the determination of policy of his government. It is my contention that apart from regional ministers, the number of central government ministers may not have to exceed 19, as contained in the Constitution. And that means ministries shall also not have to exceed 19. All ministers, to be relevant and to be able to assist in the evolution and determination of policy in their sectors, must be cabinet ministers. The excess numbers must be cut off, and that would significantly reduce public expenditure. For the avoidance of doubt, the Constitution must provide for that. Now, Article 68 provides, among other things, and I'm quoting, whenever the president is absent from Ghana or is for any other reason unable to perform the functions of his office, the Vice President shall perform the functions of the President until the President returns. That construct, let me go over it again. It says, whenever the President is absent from Ghana or is for any other reason unable to perform the functions of his office. Inherent in that construction is that when the President travels outside the country, he's unable to perform his functions as a President. Is that the case? Does the mere absence of the President from Ghana mean inability to perform the functions of his office? This cannot be true in this technological age, or in situations where the President exits the jurisdiction in his capacity as President to perform official duties for the country. For instance, he attends meeting at the United Nations. When he goes, he's still the President. So why do we say that he's not able to perform his functions as the President? And for that matter, have the Vice President sworn in, and the Vice President is not there, to have the Speaker of Parliament sworn in as acting President. The man is there performing his duty as the President of the Republic. We need to amend this provision. Mr. Chairman, Article 78(1) provides for a President to appoint a Minister of State with the prior approval of Parliament. When a Minister of State is nominated by the President for a specific ministry, he is vetted for that ministry. If for any reason the President has to move that person to another sector, Parliament must vet the person again for that new position in order to satisfy themselves that the person has some competence and knowledge for that new designation. Otherwise, there may not be any value addition in these reshuffles. You are nominated as Minister for Agriculture. You are so vetted as Minister of Agriculture. The next moment, you are shifted to maybe finance, and you don't come before Parliament again for vetting. How do we assess your competence in that area, in that new area? It would be better for us to assess the competence of any minister or deputy minister if that person is reshuffled in the court of Parliament via the appointment committee. We must all acknowledge that ministerial or deputy ministerial appointment is serious business and should not be reduced to trial and error, because government is about lives of people. In the United States of America, you are appointed to a ministry. They call them secretaries. If you perform, you are maintained. If you don't perform, you are taken out. You are not reshuffled to another ministry. If you have to be reshuffled, you have to face the vetting committee of the Senate, of Congress. That's how it's done. Not so in our part of the world. And I'm saying that is not adding value to our governance. Now, let me say a few words about the Attorney General. The Attorney General, who is a principal legal advisor to the government, is a Minister of State appointed by an incumbent president. That is Article 88 of the Constitution. The Attorney General is responsible for the initiation and conduct of all prosecutions of criminal offenses, Article 88(3). All offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any person bearing the authority of the Attorney General. If the Attorney General is a minister in a ruling party's government, certainly human as he is, he would tend to treat his colleague ministers with kid gloves and only go after opposition elements and former ministers. That's what we have. It is proper and prudent to insulate the Attorney General and assure his independence. For instance, the status of the Attorney General could be made equivalent to the Chief Justice, or at least a Justice of the Supreme Court. He must not be a Minister of State appointed by a president. By that, he would traverse several administrations, his financial autonomy will be guaranteed, and then shall we witness the demonstrable prowess of an Attorney General. An amendment to Article 88 is required. The National Development Planning Commission. The National Development Planning Commission is a vital cog in the development agenda of this country. The broad architecture of national development is provided, as I've already indicated, by the directive principles of state policy, expressed in the broad ambit of political objectives, economic objectives, social objectives, educational objectives, cultural objectives, and international relations objectives. The National Development Planning Commission is mandated to craft a long-term development plan for these development themes for the nation, based upon which the various political parties are required to craft their manifestos, as required by Article 55(3) of the Constitution. When this has been achieved, then the relevance of Article 35(7), which provides, and I'm quoting Article 35(7), as far as practicable, a government shall continue and execute projects and programs commenced by the previous governments. The relevance of this then shall be established, because the NDPC would have crafted a long-term development plan. The political parties would have crafted their manifestos, indeed woven their manifestos around the long-term national development plan. And then the obligation imposed by Article 35(7) then will be relevant, because we are singing the same tune. And so when this party, we may only differ in the details of application of the development plan. We shall have a common national development plan for ourselves. Now, this has become difficult to achieve because the political parties have no guide from the NDPC. On the part of the NDPC, it is not for want of trying. The truth of the matter is that the very composition of the NDPC, as provided under Article 86, makes it politically tainted. If you look at Article 86, the vast majority of the membership of NDPC is ministers of state at any given time. So regardless of the quality of the product, if it is done by MPP, NDC doesn't want to have anything to do with it. If it's done by NDC, the MPP doesn't want to have anything to do with it. I believe that the provision on the NDPC, especially in respect of the composition, that is ministers from one political party, Article 86(2), shall have to be amended to strengthen its role and serve as the principal driver of the national development plan, of the national development agenda, with the long-term development plans that they shall craft. Now, let me say a few words about the Electoral Commission. This is a body that occupies a central role in the framework of government that we have established. Its commissions or omissions could either advance our democracy or draw back our democracy. It is the responsibility of the Commission to, quote, demarcate the electoral boundaries for both national and local government elections. That is Article 45(b). The Commission is charged with the function to, I'm quoting again, to review the divisions of Ghana into constituencies at intervals of not less than 7 years or within 12 months after the publication of the enumeration figures, after the holding of a census of the population of Ghana, whichever is earlier, and may, as a result, alter the constituencies of the country, Article 47(5). It is the combined effect of Article 47(b), 45(b), and 47(5), which drives the creation of additional constituencies by the Electoral Commission without any regard to Article 47(3), which provides that, and I'm quoting, the boundaries of such constituencies shall be such that the number of inhabitants in the constituency is as nearly as possible equal to the population quota. Democracy is about representation, and representation is about people by people. It's not about representation of trees and landmass. So you remember in 2013, when the MPP sent their case to the Supreme Court, and the Electoral Commissioner was asked to tell this country the population quota, he never got around that question. He never answered it. What it all means is that if we now have 275 constituencies, because democracy is about representation of people by people, we should have the number of inhabitants in all the constituencies as nearly as possible equal. So if the population quota now is maybe, the population now in this country is about 31 million. 270 divided by 275 will give you the population quota. So if, say, maybe you have 120,000, what it means is that we can give ourselves a band So 120,000, let's say plus or minus 20,000. What it means is that if the population scales over 140,000, the excess should go into the contiguous constituency. If it is less than, let's say, 100,000, then that constituency ought to be meshed with some others. That is what obtains everywhere in the civilized and established democracies. Not so in Ghana. We keep increasing our number of seats. Where does this obtain in the world? It doesn't obtain anywhere in the world, what we are doing in Ghana. So what it means is that, you remember, those of you who are a bit older, in 1992, before the conduct of the first elections under the Fourth Republic, the constituencies in this country were 140. They were increased by 60 to 200. Then, at the time of President Kufuor, about 10 years after the exercise, it was increased by 30 to 230. 8 years after that, they increased it again by 45. Today, right? That was done in 2012. 10 years has now expired. And as the Constitution provides, after the conduct of census, we should do it. What's the Electoral Commission going to say? Are they going to increase the number of seats again? That's the difficulty. It's certainly not sustainable. And if we should keep on doing that, what it means is that maybe every 20 years, we should be building a new chamber for Parliament. But when you want to build a new chamber, you are met with hashtag drop the chamber. So, ladies and gentlemen, I think we should be realistic. Everywhere the number of seats is set, it's the population quota that changes, not the number of seats in the Parliament. I guess we may also have to look at the composition of the Electoral Commission, because it also excites a lot of agitation. On some occasions, agitation is muted. On other occasions, the agitations are very loud, depending on which party is in opposition and which party is in government. And of course, which party's president makes the appointment of the members of the commission. Should the appointment of the commissioners be subject to parliamentary approval? Should the commissioners be appointed to serve for a defined term? Let's say maybe 4 years. Should the membership include party officers? I submit that the time has come for us to look at the matter of the composition of the Electoral Commission as a matter of urgency. Elections have the potential of triggering strife in many African countries. We should not allow any negative incident to happen before we rush to firefight. Now, the legislature, Parliament itself. The core functions of any Parliament are: 1, representation of constituents, deliberation on matters that come before the House, information dissemination, legislation, the power of pairs function, oversight, ratification of treaties, conventions, protocols, agreements, including loans, etc. These functions are either not provided at all or not sufficiently captured in Chapter 10, that is Articles 93 to 124 of the Constitution. This certainly is a critical omission that must be addressed in any review of the Constitution. The functions of the local level assemblies, that's these assemblies, are clearly prescribed under Article 245. And yet the functions of the National Assembly, that's Parliament, are not prescribed in the Constitution. However it happened, I cannot tell. Again, the functions of the presiding members, and indeed the DCs, at the level of the lower assemblies, are prescribed in the Constitution, Article 243. And yet, that of the Speaker of the National Assembly Parliament is not prescribed, apart from it being said that the Speaker shall preside at the sittings of the House. But go to Article 241, 243, you see what has been captured for the DCs and the presiding officers at the lower levels. The Constitution certainly requires to provide further clarification on the role of the third citizen of the land. I think I am hearing these days that the third citizen is inching to become the second citizen of the land. But it hasn't come from me. It's come from he himself. The 1992 Constitution, in Article 179, 1 and 2, only provides for the national budget. I've told you that a critical function, a primary function of Parliament is the power of purse, which they do by scrutinizing budgets. But Article 179, 1 and 2 of the Constitution only provides for the national budget to be laid in Parliament for the information of members of Parliament. Only. Your Constitution does not provide that Parliament shall scrutinize your budget and approve of it. I don't know how that omission arose. So you look at Article 179, clauses 1 and 2. It only provides for the national budget to be laid in Parliament for the information of Parliament. But surprisingly, not for the scrutiny or approval. That must be a serious oversight. It must be corrected. Indeed, the Constitution grants Parliament the authority to approve of supplementary budgets. That is, in any time, in any year, if the need arises to increase expenditure or have recourse to additional revenue, when we have to come to Parliament with a supplementary budget. Then Article 179, 8 and 9 says that Parliament shall approve of the supplementary budget. But the main budget, the Constitution says that it's for the information of Parliament. That indeed is an oversight. Parliament is also required to approve of the vote on account, usually in an election year. Not knowing which party may win the next election, Parliament approves of what is called a vote on account. That is for only the first 3 months after the election. So it is said that Parliament approves of that. But the main budget, as I've told you, Parliament has no hand in approving of it. I do know that by the provisions of Parliament's own standing orders, Parliament has given itself the authority to scrutinize and approve budgets presented on behalf of the President. But as I've said, sad to relate that has no constitutional basis. I've earlier spoken about the optimum number of seats or constituencies that as a nation we should determine. The population quota, I think I've spoken about that. But let me say that we also need, as a country, to attend to the mode of choosing members of parliamentary candidates. We must interrogate it, and the various political parties must do so. The political parties are, by the current method, where every 4 years their sluice gates are open to all comers without letting the candidates go through any mill, encouraging the entry into Parliament of persons who have no or little clue about the functions of Parliament or parliamentarians. Mediocrity is being bred in Parliament, with respect. Any wonder that in recent times, members of Parliament are displaying muscle power instead of brain power? The four-year ritual of sluice gates opening to all comers is also encouraging the invasion of money bags in the various constituencies. The consequent high attrition rate is down-warping parliamentary democracy in Ghana. Distinguished invited guests, it takes considerable period to build the capacity of a typical parliamentarian. 4 years is grossly inadequate. And that is why the constant peeling of experienced members or even up and coming members is not helpful. Let the political parties take note. And for those who seek vainglory, in Article 55(5) of the Constitution, which provides that the internal organization of political parties shall be democratic. I want to juxtapose that with what Article 55(9) of the Constitution provides, when it says that the national executives of every political party shall be chosen from all the regions. It doesn't use the word elected. Choosing is a way of selecting representatives. So, colleagues, let's not deceive ourselves when we say that, the parties here democratic. We know where we are going. Let's not pretend. In the Constitution, the voting rights of deputy speakers or any member of parliament presiding as the speaker are not clearly stated. And that has given cause to the recent political vigilantism, or perhaps much more appropriately, foot soldierism in parliament, of all places. In jurisdictions where speakers are members of parliament, the speakers have voting rights. When the MP speaker presides, he may not have an original vote from the chair, or he may not exercise his original vote from the chair. But they all have casting votes, even where by practice they don't have original votes. Whereas in Canada, they want to exercise an original vote, they must cede the chair to a deputy speaker. We need to amend the Constitution to shed more light on this. We don't have to fight on this. I thought this is commonsensical. Why people should move to try to assault a speaker in Ghana. I never, ever envisaged that such a thing could happen in Ghana's parliament. Now, given the antecedents of January 7th, 2005, remember January 7th, 2005, when Parliament came to electing Bejina Sachi Hughes as the speaker. And then we had to vote between Sachi Hughes and Peter Lajete, who was the previous speaker. And then January 7, 2021, what happened? The fight. It does seem to me that the nation now, more than ever, needs a Parliamentary Transition Act, an important component of which shall be when to elect the Speaker of Parliament. It should be possible for a newly elected parliamentarians to be summoned by the clerk to Parliament to elect the Speaker of Parliament before January 7th. And when that has been accomplished, the Speaker would not be sworn in. Because if the Speaker is sworn in by the Chief Justice, then one could say that we're having two parliaments running pari passu. But that Speaker will not be sworn in. He'll be elected by the newly elected members of Parliament. Then he will wait and then be sworn in on January 7th. That is after the holding Parliament would have dissolved. The nation will be spared the agony of sitting on tenterhooks and the embarrassment that may unfold before the invited high-profile guests to a swearing-in of the president, as happened on January 7th, 2005, and much more embarrassingly and shamefully on January 7th, 2021. A Speaker of Parliament who has not been sworn in by the Chief Justice cannot swear in parliamentarians elect, and therefore the mischief of perhaps having two parliaments running pari passu, as I've said, would not arise in the first place. These strands of the anchor must be attended to. In Ghana, our Constitution, Article 124, provides for a parliamentary service board. The service board, as structured, provides only for the staff, not members of Parliament. So, given that situation, we have speakers of Parliament who would want to reduce Parliament into their personal kingdoms and do whatever pleases them. I think the Constitution will have to look at this, because elsewhere we have what is called the Parliamentary Commission, which looks at the affairs of members of Parliament. Our case, the Service Board does not take charge of the members of Parliament. The imperatives of Article 108 should also be considered. Article 108, in the considered opinion of many, seeks to forbid Parliament in the exercise of arguably its prime function, legislation. Parliament since 1997 has been endeavoring to find its way around this. It started with Peter Lajete, but his efforts did not yield much, since not too long after the exercise started, presidential and general elections came to be held, and his party did not repeat him as Speaker. 108 just says that Parliament shall not, and I'm quoting, unless a bill is introduced or a motion is introduced by or on behalf of the President, proceed upon a bill, including an amendment to the bill, that, in the opinion of the person presiding, makes provision for any of the following: the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction, or B, the payment, issue, or withdrawal from the consolidated or other public funds of Ghana, any money is not charged on the consolidated fund, or any increase in the amount of that payment, issue, or withdrawal. So, if the person presiding thinks that this bill would exact a toll on the consolidated fund, then he will not allow the bill. And if you stretch it, when you have done any bill, the paper on which it must be typed and printed is at public expense. It's from the consolidated fund. So the Speaker can say that, well, because of this, I'll not allow it. And yet we all do know that a prime function of Parliament is legislation. So how do we get around this? Indeed, today, if we come to Parliament, there's an avalanche of bills and motions pending in Parliament, private members, and the Speaker is allowing it. The question to ask is, does the current Speaker not have any opinion on these substantive bills? Or is it the case that the Speaker thinks that these bills shall not impose any charge on the consolidated fund or other public funds of Ghana? And if not, how are the bills, after passage by Parliament, going to be funded in their implementation? What is going to be the effect of these bills if Parliament passes them on the budget that has already been passed? Is Parliament, in the face of the imperatives of Article 108, deliberately setting itself on a collision course with the executive? These are relevant questions. Notwithstanding the express provision of Article 108, however, the legislative responsibility of Parliament must be discharged. In particular, Article 103(3), which provides, and I'm quoting, committees of Parliament shall be charged with such functions, including the investigation and inquiry into the activities and administrations of ministries, departments, as Parliament may determine, and such investigation and inquiries may extend to proposals for legislation. How is this to be done without any confrontation between the executive and the legislature? So, distinguished colleagues, these are matters that should concern all of us, to force us or to compel us to have a revisit to the Constitution. In recent times, some members of Parliament have had encounters with the law enforcement agencies. Previous speakers have had a way about this. But lately, some wranglings are dominating the airwaves relating to witch hunting. In the face of Article 117, which provides, and I'm quoting Article 117, it says, civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a Member of Parliament or a clerk to Parliament while on his way to, attending at, or returning from proceedings of Parliament. You see the danger? So if I'm driving to Parliament and I knock a pedestrian down and kill him, I am on my way to Parliament. What it means is that I cannot be served with any process. When I get to Parliament, I cannot be served with any process because I'm in Parliament attending to the business of Parliament. When I leave Parliament, the Constitution provides that I am leaving the proceedings, I'm returning from the proceedings of Parliament, so I cannot be arrested. And yet, the law is no respecter of human beings. How do we resolve this conundrum? We should have a second look at the Constitution. And sometimes when the current IGP makes bold to confront some members, he is accused of unwarranted damparic intrusions. Gratuities to members of Parliament. I think it's important to talk about this. Article 71 of the Constitution provides for the President to determine the salaries and allowances payable and facilities and privileges available to public officers listed under Article 71(1)(a). Whilst Parliament makes the determination in respect of the President, Vice President, Chairman, and other members of the Council of State, Ministers of State, and Deputy Ministers, upon the recommendation of a committee that is established by the President. These amounts that are paid are gratuities, not ex gratia. First of all, let's purge ourselves of these semantics. A gratuity is a sum of money given for a good service or long service, whereas ex gratia is an amount that is given to somebody as a favor, not in recognition of any obligation. The amounts given to the members of parliament, ministers of state, the president, and so on, are for good service to the country. And in any event, if you go to Article 71, it does not relate to members of parliament only. And yet, at the end of every 4 years, it is only members of parliament who come under the govt and ministers. Let me say that I think the time has come for us to tweak the Constitution so that this does not become a 4-year ritual. The president sets up the commission, and then we build into the recommendation some dynamics such that at the end of every year, we shall have some triggers, and that will affect the emoluments of the officers listed under Article 71. If you are employed, Provice, if you enter into the university as a lecturer, the day you enter, you know your conditions of service. Is that not the case? A member of parliament does not have his conditions of service determined. So you go there, and you are paid the emoluments of the old members of parliament until the committee is set up. And because the presidents are hypersensitive to labor agitations, they don't set up the committees on time. In terms of setting up, we are on your back pay kakra. Na my force so my force you trouble sir na bende. Now, the judiciary, the Supreme Court, the highest court of the land, comprises the Chief Justice and not less than 9 other justices of the Supreme Court. That is Article 1281. The upper limit is not set. It says that the Chief Justice and not less than 9. So a minimum of 10. There's no ceiling. There's no upper limit. We have seen instances when numbers have shot up to about 15, 14, 15. The time has come for us to prevent any absurdities. Let us set an upper limit in the Constitution, say the Chief Justice, and not more than 12 or 14 others. And that would even avoid even numbers. If the Chief Justice plus 12 others, that would make a total of 13. A Chief Justice plus 14 others, a maximum of 14 others, that would make a total of 15. So that when they preside, when we have a full house of the Supreme Court, there will not be any even numbers. Here it says 9, the Chief Justice plus 9 others. So we could have a minimum of 10, and when they decide on the case, sitting fully, there could be a split decision, which is not good. So you see that oftentimes when the Supreme Court has to sit as a full house, one of them will excuse himself or herself. We shouldn't have. And then the qualification criteria of justices of the Supreme Court, the apex court of the land. The Constitution provides in Article 1284, and I'm quoting, a person shall not be qualified for appointment as justice of the Supreme Court unless he is, 3 things they say, he is of high moral character, 2, proven integrity, and not less than 15 years standing as a lawyer. These are only the 3 qualifications to qualify to serve on the Supreme Court. Just that. Undoubtedly, the bar, in my view, is too low. Check the qualification and eligibility criteria of parliamentarians by Article 94. And yes, members of parliament don't compare to justices of the Supreme Court. And yet, our qualification criteria is higher than the Supreme Court justices. In fact, we are, if you look at other public officers, like the Electoral Commission, the chairman of the Electoral Commission, he or she is equated to an appeal court justice. And yet, when you look at Article 94, the qualification and eligibility criteria set for them is higher than that of the Supreme Court justices. That certainly is anomalous. And I believe that we have to have a second look at that. To whom much is given, certainly much is expected. Now, Article 126 of the Constitution provides for the composition and mode of exercise of power by the judiciary. And Article 126 states, I'm quoting that. The judiciary of Ghana shall consist of, in other words, the judiciary of Ghana shall or must consist of, and they list this, the superior courts of judicature comprising 1, the Supreme Court, the Court of Appeal, the High Court, and regional tribunals. Professor Che, the regional tribunals are still a composite part of our superior courts. But I thought the tribunal, citizens or peoples, died with the revolution. And yet the 1992 Constitution still has it, that the regional tribunals are part of our judicial system. Their ghost still exists in the Constitution. So we have to look at that. The Auditor General. The Auditor General is a tool for Parliament in the performance of our oversight responsibilities over the executive and the other arms of government. It is the reason why the Constitution provides that the Auditor General, when he finishes his work, should submit his report to Parliament. Until and unless he submits his report to Parliament, his own work is not complete. So when you have situations where, as in the recent past, we had an Auditor General who will finish his work, not submit the report to Parliament, and begin leaking the report to the media. And the media descend on the victims, tear them into shreds, only for them to appear before the appointment committee, the Public Accounts Committee. And in some cases, the Auditor General, staff from the Auditor General's office will come and apologize for what they did. And apologize to those people. Does it make sense to do that? We have to look at the Constitution again. And again, the Auditor General, as I said, is a tool for Parliament in the performance of our oversight responsibilities. It is surprising that Ghana's Constitution, in Article 187(7), whereas it provides that the Auditor General in the performance of his duties is not subject to the control or direction of anybody, including Parliament. 187(8) exempts the President. It says the President, on the advice or in consultation with the Council of State, can direct the Auditor General to investigate suspected cases of malfeasance. Parliament, that the Auditor General works to, cannot direct the Auditor General to do that. What are we doing to ourselves? Clearly, that provision was put there to satisfy somebody whose name I shall not mention. So we have to look at the provision of the Auditor General again. Now let me talk a bit about assets declaration. Article 286 provides for certain categories of public office holders to submit to the Auditor General a written declaration of all properties or assets owned by or liabilities owed by the office holders, whether directly or indirectly. The purpose for declaration of assets and liabilities is for taxation. It's for taxation, and also to ensure that the person has a clean bill of health and that assets do not ensue from money laundering or ill-gotten wealth. Not so in Ghana, where assets that are declared are kept under lock and key by the Auditor General. The Constitution provides that once you declare your assets to the Auditor General, he cannot open it. He must put it under lock and key. So it explains why somebody went on air, I think 2 years ago, and declared openly that, oh, at the last count, I had 120 houses. Why, Adepa, you had 120 houses? What's the value of those properties? Individually and collectively. How much property rates? You have 120 houses. Why are they? How much property rates have you paid to the various disassemblies where the houses are situated? The Auditor General must have the capacity to go into these. A review of the Constitution will yield that. Tax authorities in other jurisdictions, when he made that declaration, the tax authorities would have descended on him. Jack, if you know him, let's go and value the houses and assess it for you to pay the relevant tax, and also for us to investigate where you got your money from. And yet, that was the end of it. The Constitution provides for the President to appoint district chief executives with the prior approval of not less than 2/3 majority of members of the Assembly present and voting. The argument has always been that there's not much accountability at the base level of government because DCs are appointed by the President. If they submit themselves to elections, there will be greater transparency and accountability. That means that Article 248 shall have to be revisited. It also has been suggested that whereas Article 2522 provides for an allocation of not less than 5% of total revenues of Ghana to be made available to the District Assembly for development, it's simply not possible to grant 5% of all total revenues to the District Assemblies when compensation, that is emoluments, and debt servicing and debt amortization is consuming about 100% of total revenue. You have debts to service. You have debts to service. You must pay your debts. You must service your debts as well. You must pay the people that you have employed in public office. But the Constitution is forcing government to go and pay 5% of all revenues, total revenues, to the assemblies. How does it happen? You must find a way about it, especially given the fact that every year the Auditor General's report is replete with scandalous and colossal waste of resources at the level of the district assemblies. How do we do that? Is it the case that we want deliberately to throw money down the drain? We must interrogate this to proffer necessary amendments to the Constitution. I'm not saying that we don't have to capitalize the assemblies or give money to assemblies to perform, but I'm saying it appears ridiculous now to say to ourselves that whatever it is, 5% of total revenue should go to the district assemblies. Now, Professor Chair, let me attempt one more comment on the transitional provisions. The transitional provisions were inserted in the Constitution to serve ostensibly for a transient period. It was to serve a temporary purpose to all intents and purposes, to help the dust from the blood and tender days of the revolution to settle. However, since 1992, and as the years have rolled by, and given the brazen ruggedness of the language employed in the transitional provisions, it appears that those provisions are anything but transitional. The indemnity clause of the transitional provisions, clause 34, in section 1 and 3, are very ominous, as they put the executive, parliament, and judiciary to permanent sleep on what remedy to propose. Clause 34.1 provides, and I'm quoting that clause 34.1 for obvious reasons. Quote, no member of the Provisional National Defense Council, the PNDC, the secretary to the PNDC, or other appointees of the PNDC shall be held liable, either jointly or severally, for any act or omission during the administration of the PNDC. And 34.3 adds, for the avoidance of doubt, it is declared that no executive, legislative, or judicial action taken or purported to have been taken by the PNDC or the AFRC, or a member of the PNDC or the AFRC, or by any person appointed by the PNDC or the AFRC, in the name of either the PNDC or AFRC, shall be questioned in any proceedings whatsoever, and accordingly, it shall not be lawful for any court or tribunal to make any order or grant any remedy or relief in respect of any such act, unquote. These are cast in stone enactments. It is interesting to observe that Flight Lieutenant Rawlins was the only person who, as the first president of the Republic, was given the authority to do something about the transitional provisions under Clause 30, which states, and I'm quoting Clause 30 of the transitional provisions, the first president under the Constitution may, at any time within 12 months after assuming office as president, by constitutional instrument, make such provisions as may appear necessary for repealing, modifying, adding to, or otherwise for giving effect to this Constitution. Suffice it to say that President Rawlings did nothing, and with that, the door was shut at all other presidents. However, the Supreme Court has held that, and I'm quoting the Ghana Law Report, 2010, page 429. It says, the Supreme Court, I'm quoting, the Supreme Court could nullify an existing law only if, at the time it was passed, it was invalid or its continued operation conflicts with the Constitution. That is on page 429 of the Supreme Court of Ghana Law Report 2010. A justice of the Supreme Court held, and I quote, let me add that section 34(3), that is what I quoted in the transitional provisions, of the transitional provisions of 1982 Constitution, was passed at a rather abnormal time. So far as good governance is concerned, and nobody could challenge it at the time. The indemnity provision in the transitional provisions is to make sure that when the time comes, when the time returns to normal, that is under a properly elected government in a constitutional regime, the law could still not be challenged. That's the opinion of a Supreme Court justice. That's a strong view of the learned justice of the Supreme Court. The question is, for how long can the nation live with this albatross? I believe the time has come for us to introspect on this also. Professor Chairman, the amendment procedure of the Constitution itself, established for entrenched provisions, are both tortuous and torturous, to say the least. Many of the provisions we have related to are entrenched, and each one of them shall require a referendum of yes or no. With regard to the non-entrenched provisions, the amendment path is not serenaded by legato. It requires painstaking efforts, and the exercise could suffer political twists and turns, as happened in the attempt to have district chief executives elected by universal adult suffrage. Professor Chairman, distinguished ladies and gentlemen, I must express my profound gratitude to you, all of you, for tolerating me for so long. There are many areas that I've not been able to touch on because of lack of adequate time. I, however, want to believe that I provided some food for thought on the subject matter, on the need for a constitutional review. Once again, I thank you all very sincerely, and I believe that in the coming days and weeks, it should be possible for all of us to digest, add to, or subtract from what ideas that I've shared. But let me quickly add that these ideas are my personal ideas, not that of the MPP administration, or even the majority caucus in Parliament, which I heard, or the House of Parliament, for which I serve as a leader. They are entirely my thoughts. I thank you once again, and may God bless our homeland, Ghana.
A louder round of applause to our Speaker, Honorable Osei Kyei-Mensah-Bonsu. Please be seated. So we just heard our Speaker's delivery on constitutional review, the perspective of a legislator. every day of our lives, we hear the perspective of the ordinary Ghanaian on radio. And our speaker's delivery seems to trumpet the sentiments of the public. As to whether it will see the light of day, I can't really tell. So, next on our agenda, it's labeled Interaction with the Speaker, and I've been told it means questions. So, I have microphones here we're going to pass around. We'll spend the next few minutes to pick your questions and get our speaker to address them, and then we wrap up on the program. So if you have a question, kindly raise up your hand wherever you are, and ushers, please assist me to pass the microphone around. Let's take the questions and get our speaker to address them. Before we take the questions, I would want to acknowledge the presence. I would want to acknowledge the presence of the Honorable Member of Asuka Constituency, Madam Patricia Apieje. Okay, so our first question, please, your name, and then go ahead with your question.
Neso Sudapa Dean, Faculty of Law. We'd like to thank the eminent lecturer, Honorable Osei Kyei-Mensah-Bonsu, for erudite delivery and very honest observation about the workings of our Constitution. And I'm happy that April 2022 marked 30 years when all of us line up in a referendum to approve the Constitution. Now, I would like to put on record that from the point of view of contemporary legal political history, the 1992 Constitution could best be described as a political settlement carefully negotiated to say goodbye to military regime and pave way for constitutional democratic dispensation. That being the case, there are a lot of things in the Constitution. If Ghanaians were asked on ordinary day to decide whether they would like it to be part of the Constitution or not, I would like to agree with the general wisdom of the Speaker that we have probably made some other options. That certainly shows why the regional tribunal, as he rightly said, the people died of the revolution. Why do we still have it on the constitutional tablet? Of course, it's part of the things that we had to embrace in order to usher in the new system. Thankfully, that has not been abused in the last 2.5 decades, because you notice that we don't have the regional tribunal actually operating anywhere in the country. But that aside, I would like to commend the 360 degrees review which the Speaker has given. My only worry is that in 2010, I remember the Constitutional Review Commission work, which was largely bipartisan in the sense that if you look at the members of the commission set up by the then president, it was made up of representatives from broad spectrum of our political divide, as well as lawyers and other academics. Now, that culminated in a very useful report. I mean, sad to say that some of the good things which the commission recommended were actually jettisoned in the white paper, which the subsequent government issued on that report. But listen to the suggestions being put up for our thinking as we seek to
So, Dean, respectfully, what is your question?
My question is that the Speaker did not situate his some of his recommendations within that which have already been put forward. And I would have loved to see that, because the report of the Constitutional Review Commission is a report for Ghana, and it is already there, we've not implemented it.
Okay.
One would have wished that you show us maybe those aspects which are deficient, and certainly some aspects are deficient, and then we build upon it.
Okay.
Because these are not things which are being considered for the very first time.
Thank you very much. Thank you very much, Dean. So, one question from my right. Your name and straight to the question, please. Okay, so let's go ahead with you.
Okay, thank you very much, the majority leader. Now, the question I have for you is this. Why are our politicians exempted from the compulsory retirement age? And, yes, why are our politicians exempted from the compulsory retirement age? And given the considerations for review, would you support a situation where our political people also get an age limit on how they can function in political life?
Thank you. Please identify yourself, because he will address you.
I am Kofi Boateng from the business school.
All right,
thank you.
Thank you. So let's take one more question.
Yes, sir. Thank you very much.
Please identify yourself. And
my name is Banchani John Paul. I'm in the Department of Politics. Thank you very much, Honorable Member of Parliament. You did articulate so well the question of the institutional design of our Constitution and the remedies. You did discuss them so elaborately. My problem, and what I would like you to probably address, is what is your general framework, and what approach do you recommend going forward with our constitutional review? Thank you.
okay. So please pass the mic on. Unfortunately, we are having to do with one microphone, so please forgive us. Let's be fast, please. Okay.
Thank you very much. My name is Emil Amaibo, Speaker of Grasa KNUST. My question is very simple. I would want to go straight to the point. Given the Speaker's vast years of experience as a legislator, I wish to find out from him what is his take on which parliamentary system will be better suited for Ghana, given the fact that we are currently practicing a blend of the presidential and the parliamentary system. What is his personal take on which of these two systems will be better suited for Ghana? Thank you.
All right, thank you. A fifth question, and then our speaker addresses the 5 questions.
Thank you so much, Honorable Kyei-Mensah-Bonsu, for such submissions. Thank you. I would like to ask, I'm Emmanuel from Faculty of Law, a student, second-year student. Respectfully, I would like to ask about the rationale behind the Article 71 holders' rationale for the framers of the Constitution having that special provisions to the detriment of other workers of the country, because we are all building a nation, Ghana. All right, today as we speak, and I'm a teacher by profession, I'm wearing a t-shirt as a teacher. They walk out of the deliberations with respect to the labor commissions, and then per the meeting that they had, teachers walk out, all because per the salary, there is nothing to talk home about.
Thank you. Your question is, is being asked,
so I want to know the rationale per the framers of the Constitution having the Article 71, especially for other people, to the detriment of other workers of the country. Thank you.
I would invite our speaker to address the 5 questions, and then we go for the next set of 5 questions. So, Honorable.
Thank you very much. The Dean of the Faculty of Law, your question is what happens to the Constitutional Review Committee's work? I think that if we come to dealing with a holistic review of the Constitution, I believe that certainly it's going to be one of the source documents. But first of all, the attempt by Professor Mills was useful, but you as the dean would agree with me that for the president to wake up one morning to tell us that I realize that there are a few areas in the Constitution where there are difficulties, and I'm appointing these people to constitute a team to go into it. The very basis of it was faulty. The very basis of how the people came. You are telling me that membership was representative. I don't see how representative it was. If I want the University Teachers Association to have a representative on a body that we want to constitute, you give it to them. Bring your representative. If I come to your backyard and appoint Professor Osei, he may not represent the interests of the University Teachers Association. So, I mean, the very way of constituting it was problematic. And that is not to say that they didn't do any good work. They did quite a good work, but I'm saying the basis for composing it. And then the outcome is also challenging. If you've seen the report, they've brought together their recommendations in one basket. Some of them entrenched, others not entrenched. How are you going to deal with them? And that's why I'm saying that, you see, this discussion that we're having is useful to the extent that if we escalate it to a national level discourse, we have cross-sectional representation in this country, from parliament, from the judiciary, from organized labor, from civil service, public service, the Council of Vice-Chancellors and so on. We send invitations to all of them. Please come. Let's dialogue on this. Bar Association, the Judicial Council, Parliament itself. Then we have these composite members coming with their own representatives. Then we sit down, maybe for 3 days we are dialoguing, out of which we'll have maybe a constituent or a consultative assembly. That will be much more holistic. So, yes, Prof did well, but if you ask me, I think that the very way it was structured and it was formed certainly was not the best. That's how come that the outcome still is suffering from glaucoma in one eye and cataract in the other eye. But certainly, it was some useful work that has been done. And as I'm saying, it could provide a very good source document for all of us. Then the second person, Kofi Kwarteng, asked, why are politicians exempted from compulsory retirement? We trace it to the Constitution. When it says about us that maybe the president shall be of a minimum of 40 years. For members of parliament, 21 years. 18 years you can vote, but to qualify to be a member of parliament, you should have attained 21 years. There's no upper limit. So again, the source is the Constitution. If we want us to place an upper limit of years, let's go back to that. And then we have clarity in our minds that, yes, maybe 70 years, you can't any longer go on, right? So it's for us. It's part of the exercise that I believe we're starting in earnest. And the third person asks, what framework of government do I recommend? I have just painted a picture. You have to caption the picture the way you want. But if you ask me, and I told us that where we are going as a nation is not sustainable. we're getting on a very slippery road in terms of monetizing our politics, both parliamentary elections and presidential elections. And I think that, as a matter of fact, my personal preference is with the Westminster type, where the prime ministers are much more accessible to us. One, and then in terms of expenditures, they spend more. They spend far, far less in getting themselves elected from the constituencies, right? And that obligation to satisfy sponsors is much, much less. And with that, we'll be able to deal with corruption. And then again, because the prime minister is a member of parliament, peer review should tell you that you can't be a prime minister when I know that before you became a prime minister, you had only one house. And 4 years after becoming a prime minister, you have 10 houses. My friend, where did you get it from? Peer review will keep these things down. I told us that with the ministers, before a person becomes a minister, would have served in parliament for a very long time. And have served on a committee 2 terms, 3 terms, become maybe a chairman, vice chairman, risen to a shadow minister for about 4 terms in his life as a member of parliament. When his party wins, there's that automaticity that the shadow minister then becomes the minister. But there's no nook and cranny in the ministry that he doesn't know. And so you see manifest value addition when he's made a minister. If you have to go presidential, let's do that. The hybrid system has served us. And I agree with the dean that this constitution is a political settlement document. It was meant to settle those of them who had their own ambitions, and we needed to stabilize the system, stabilize the country. It served its purpose. Don't forget that the petty jealousies that arose between the members of parliament under President Hilary Liman in 1981 occasioned the cracks, because they were saying that the ministers had not fought elections. They had been made ministers, and they were enjoying at the expense of the members of parliament who had fought elections. Then cracks developed within the front of the party that had overwhelming majority in parliament. They sent a budget to parliament, presented by Professor Bene, at the time who was the Minister for Finance, and it was overthrown by his own party. And then Rawlings took advantage to overthrow the government. It was from that experience that Rawlings then himself said, no. If I go this way, we may have problems. So let there be a merger. So members of parliament would also become ministers. And with that, there's been some stability in the system. But I think that it served its purpose. If we want to go presidential, let's go presidential. So that parliament then will have the full force to provide effective oversight over the executive. And the executive then would come with ministers who are professionals, who are experts in their fields, to add value to our governance. If we want to go Westminster, let's do so. So, as I said, my own preference is Westminster because of limited costs involved, and I believe that it also offers greater access to the elected by the electors. I think one person also asked about, I think this question also answers the question asked by the colleague from Grassak. The fifth one is the rationale for having the provision on Article 71 office holders. Boy, if you ask me the rationale, I wasn't part of the draft, so. As the reason why we need to interrogate it. If it serves a purpose, it serves some purpose. Let's get back to it. Let's get back to business. If we have to delete it from the Constitution, let it be so done. Let's all bring our minds together on those matters. But as I said, I think people relate it to just members of parliament, ministers, and so on and so forth. The list, if I should read to you, Article 71, is the Commissioner for Human Rights and Administrative Justice. He's there. The Auditor General is there. Nobody talks about him. The District Assembly's Common Fund, the administrator, nobody talks about him or her. The chairman and other members of the Public Services Commission, the Lands Commission, governing bodies of public operations, National Council for Higher Education, House of Rural is described. The holders of such other offices as may be prescribed under. Look, come to think of it, the chief executives of the various state enterprises, their emoluments is about 4 times that of members of parliament. Nobody talks about that. I didn't hear. Because you live with the member of parliament, you see him. So you can relate to the circumstances of the member of parliament. But that man or that woman is hiding somewhere, you don't see. Let's box everything together and discuss these matters. If we want to save costs and indeed save the limited resources that we have as a nation to develop our country. I thank you very much.
Thank you. We are running late, so we'll pick 3 more questions and wrap up. So, gentlemen, your question, please.
Okay, my name is Nana Kofi Osubidiako. I'm in year 4, Faculty of Law. Now, Mr. Speaker, I want to premise my question on two provisions. Article 57, Clause 4 of the 1992 Constitution says that without prejudice to Article 2 and also subject to prerogative writs, the president will not be brought to court for any other thing. Now, Article 2 and the prerogative writs includes the order of judicial review of mandamus, certiorari, and the rest. And in fact, the Supreme Court in the recent decision of the Republic vs. Ghana Gas has said that even where you have a private enterprise that is doing government business, the order of mandamus can be brought upon that particular private organization whose mandate is public in nature. So the Constitution by Article 2 and also the provision of the prerogative writs of mandamus, certiorari, and the rest puts kind of a cap on the powers of the executive. On the other hand, the Parliament by Article 80 says that Parliament can, by a resolution, pass a censure on a minister. So if a minister who works under a president, for example, acts in a way in which members of Parliament feel is an affront to the Constitution, the Constitution makes a provision for Parliament to pass censure on him. So, for example, 174 says that no waiver of tax should be done without prior parliamentary approval. So we have a minister who decides to cancel tax waivers or decides to cancel tax without parliamentary approval. The Constitution says that parliamentarians can pass a censure on him. Then the general body of case law that the Supreme Court has decided. My question is, in view of Article 2, that makes the president and executive and those under him amenable to the order of judicial review, in view of the special powers given to parliamentarians to censure ministers and other persons who are also acting in clear breach of constitutional provisions or in clear contempt of Parliament, do you still think that the checks and balances on the executive are insufficient to warrant a call for a wholesale review of the 1992 Constitution?
My friend, you are a law student, eh? When we gather like this. Anyway, thank you for your question. Yes, please go ahead, gentlemen.
Thank you. My name is Osei Oliver from the Department of History and Political Studies. Yeah. The Honorable Majority Leader keeps saying that we have to come to the idea that we have to review the Constitution. But I know that in policy making, there is an assumption that where you stand depends or determines where you sit. So as a majority leader, in the initial lecture, he said that the president even is a pioneer of those who are advocating for a review. So in that case, as majority leader, are we making advances in doing this review? Or if it's necessary for us to do, what is keeping us so long in doing it? Thank you.
Thank you. Last question. I haven't had a question from any female or any woman. Do we have one? Oh, okay. Please.
Mr. Chairman, thanks to the majority leader for his insightful revelations, a litany of imperfections in the Constitution. Right from the word go in 1992, 28 April, when the Constitution was, when we went to a referendum and we accepted the Constitution, Ghanaians were desperate for a return to civilian rule. At that time, I was a vigorous campaigner for yes votes. And these are some of the things that you said. Vote yes for a quick return to civilian democratic rule. Vote yes for the Constitution in the forthcoming referendum to ensure true democracy and progress. At that time, we wanted to make sure that we hurry away the PNDC regime and get into a new constitutional era. So we knew that definitely the Constitution was imperfect, the smuggled indemnity clauses and all that, what you have said. My issue now is, on we go. Are we to go so? Obviously, we must initiate action to change the Constitution. There are so many cost centers in the Constitution that even deters development. So the onus is on the political class, the leadership, political leadership of this country, to make sure that these changes and amendments are effected so that we can have a smooth running, progressive, and development-oriented Constitution that will inure to the benefit of this country. So the ball is in your court.
Thank you. So, Honorable Speaker, would you please do us the honors of addressing the questions and then...
I'm Mamie Fwa Adazikum, a constitutional law lecturer at the Faculty of Law. My question is related to the last but one person who asked the question. And beyond the content of the Constitution and all the amendments that we can do, there seems to be a constitutional impasse since the successful amendment in 1996. From your view as a legislator, Mr. MP, Honorable MP, what do you think are the factors for this impasse in amending the Constitution? Thank you.
Thank you.
I guess before I attempt to answer what I guess is going to be the last segment of questions to be asked, I must acknowledge the presence here of Nana Kyei-Mensah, the foremost dealer in building materials. The question that was asked, I think I didn't get it. The one by, I think, the lecturer at the Faculty of Law, it related to Article 57(4). I was struggling to appreciate the import of the question. I didn't get it very well. But the one on the vote of censure of ministers, and we have a motion in Parliament on a vote of censure on the minister responsible for health. It's been on the order paper for quite a while. I have a difficulty with that. And even this morning, I was talking to the ranking member on health. I have a difficulty. A vote of censure is serious business. You want to indict somebody for what commission or mission that he might have involved himself or herself in, on account of which you think the person must be censured. So you come to Parliament and you relate to it, and then a committee will be established to go into it, right? Now, in respect of the Minister of Health, such a thing came up. His conduct was referred to a committee. The special committee went into it, and he wasn't found culpable. So Parliament then voted on the report from that committee and admitted that he wasn't culpable. Then a week after, you bring a motion of censure. What does it mean? I think that, if you ask me personally, I think that the Speaker shouldn't even have admitted that motion. Why? Because there's no basis. If you want to refer, if you perhaps say that the first committee did not have much time, and so let's refer this, or maybe there's been some additional evidence which did not go before the committee that went into the matter in the first place. So you want a second committee to be constituted, or perhaps the same committee to be activated again. And then you submit the new evidence to them to act on it or probe into it. That is something. But that is not the resort. You just come by a motion that the minister should be censured. On account of what? I think that certainly is not how parliaments operate. Other than that, if we allow that, then tomorrow I can also submit a motion to say that the speaker must be censured. On account of what? That's not how parliaments operate. So we must, the operation of parliament is structured. If you think that somebody has involved himself or herself in something, in some malfeasance, and you think the person must be brought to book, let's do what is right. Maybe refer the conduct to the relevant committee, for the committee to inquire into it. And out of it, if there should be a conclusion that the person should be censured, that person will be censured. I think that is the appropriate thing to do. The issue about checks and balances, by what are related to? There are difficulties in the Constitution about how to apply it effectively. Just today, before coming here, I was having some discussion with the Speaker. He went to some two places, I think buffer stock and school feeding. On account of that, this morning he said he was going to make a report to Parliament. And I said to him this morning that I have a difficulty. Because you see, committees of Parliament are charged by the imperatives of Article 103(3) to inquire into the administration and the activities of ministries, departments, and agencies. So if somebody has whispered anything in the ears of the Speaker, I expect the Speaker to refer the matter to the relevant committee to go into it. But if you have the Speaker himself visit those places to then come and communicate to Parliament, I have a difficulty. And so this morning I told him that I appreciate his concern, but I have a difficulty with his modus operandi. Because it's for Parliament to do that. And in our particular case, the Speaker is not even a member of Parliament. So how did he undertake that assignment? On whose behalf? On behalf of Parliament? I have a difficulty. But if you are told, maybe they referred it to the relevant committee to probe into it and report to Parliament, then we can take it from there. So it's the method, but the principle I appreciate. So these are matters that we should be looking at. So we don't, and I was telling you about the conduct of the Auditor General, who told us, you know, the Auditors General probe into activities and submit reports to us. We had an Auditor General who came to Parliament and told us that he doesn't believe in the closure of audits. We have done an audit 20 years ago, and he has some evidence against anybody. He will go back into the books. I was surprised. I was surprised. And so we should really be resorting to the imperatives of the Constitution. What does it say? What must be done? If we do that, there will be peace. And then everybody will be seen to be working. It is not for nothing that Parliament operates with these committees. Our own Parliament, I keep telling us, is not functioning effectively. When we talk about oversight, people are quick to refer to the Public Accounts Committee. And yet, what the Public Accounts Committee does is post-mortem exercise. You give money to a ministry, department, or agency. They begin spending. And immediately they begin spending, the committees of Parliament would then go after the ministries, department, and agencies. We gave you X amount. You said you want to build maybe this year about 60 schools. How many have you done mid-year? We want to go on an inspection tour and report to Parliament. If for the committees to do that, the Committee on Roads, to go visiting road construction, the committee is not made up of experts. So before going, as obtains in the established democracies, they will hire the services of experts to go ahead, do the inspection, raise the issues with them. So when they go, they'll raise the issues with the contractors. That is how parliaments operate. We are not doing what is required of us. And that's the difficulty. Our constitution provides, for instance, that the committees of Parliament shall have referred to them certain matters before they activate their services. I disagree. Fancy the situation where Parliament is on recess. There is a cholera outbreak. You want to tell me that the Committee on Health cannot investigate it and report to Parliament in full time, in the fullness of time? We'll have to wait until Parliament resumes for somebody to make a statement on cholera before the Speaker refers the matter to the committee. That's not how parliaments operate. So you see, it is the way we have inflicted some wounds on ourselves. That is not liberating our parliament to do what is required of us. It's the reason why, about 5 years ago, when parliaments of Africa came to be evaluated, 13 parliaments, Ghana's parliament plays 12 out of 13 in terms of performance. Because of these things, we are not liberating the committees of parliament to be proactive. Once we do that, I believe that we have the potential of doing good work. So those are matters that should concern us. Victor Owusu, you said to us that we all understood that the Constitution was not a perfect document, but we decided to vote for it just because we wanted to rid the country of the junta. However, it has transformed itself into, from leaving the scene, we wanted to prevent them from continuance in administration and to usher us into constitutional administration. I agree with you. Don't forget that even those days, some from within our own fold were urging that we should vote no, because they said it was not a perfect document. The overwhelming majority, however, thought that even though it is not perfect, let's do with this. And in the fullness of time, we can attend to it and rid the Constitution of the imperfections. Today, by the construct of the Constitution, we have difficulties. And I was telling us that what work that was done by the Constitutional Review Committee, appointed by President Mills, so many of them, entrenched provisions, what do you do with them? You can't be, otherwise you spend every year attending to one entrenched provision, having a referendum on it, yes or no, and then we purge the Constitution of it. The next time, you can't put 3-10 entrenched provisions in one basket for one vote. How do we vote on that? That is why we should have a holistic review. In such a situation, when we have had a holistic review, then out of it maybe will be born a new constitution. We will then submit it to one referendum. It will be on a new constitution. If you vote yes for it, it supersedes the old one, and it takes the place of the old one. And then we usher ourselves into a new dispensation. That is how, where constitutions operate, if we want to have a holistic review of the Constitution. That's the process. Other than that, we'll be bogged down by tinkering with the Constitution as it is now. I will not make much progress. Lady Ifua, you spoke about an impasse. I couldn't again get the drift of the question. If you can repeat it, and I can respond to it quickly before I sit down. You said there's an impasse. I related to some of them. When I spoke about the attempt to have the MMDC submit to universal adult suffrage. In Parliament, when the proposal came before us, I, even perusing the Constitution, said that what was before us was not exhaustive enough. So I pointed out to certain other provisions, related provisions of the Constitution. I think Article 246 and some other provisions. And I said to us that we have to attend to those others because it was going to require a referendum. There were some of them that were not entrenched, that were going to really depend on what Parliament was going to be able to do. We had agreed on everything. CDD and IDEC came in and took us to Kempinski, that is the political parties in Parliament, to have a final agreement on it. We had agreed on it. Just when we were about to rise, one from within our fold, I would not mention the person's name, then said, oh, let's go and ask the political parties, the leadership of the political parties outside. They went to consult. That's how come we couldn't agree. And I was shell-shocked. So it appears that increasingly these days, we have a diktat from the political parties. And that is not right. That is not right. And it's the reason why I'm saying to us, let's do this. If we embark on this journey, no political party then will say that we don't like this. People will see that we don't want the progress of this country. So we'll come together, political parties representation from the academia, from the religious bodies, from bar association. I mean, the constituted segments of the Ghanaian society. Everybody will be on board, and we think through to see what will best serve the interests of this country. I think that will be the way to go. We should not be dogmatic about these things. We should be pragmatic and realistic. I thank you.
I shall please invite the chairman, Professor Ellis Osudabo, for his closing remarks and presentation of souvenir to the speaker.
I'm so happy that you are still alive with us, although we delayed for about an hour. Before I say anything, I would like us to give another round of applause to the excellent delivery by the majority leader and head of government business, also importantly member of parliament for the Swami constituency. He started off by giving us a little bit of introduction and ran us through the nostalgia of being in KNUST. And actually this afternoon he went to the University Hall to say hello to the folks. He went ahead to detail the different chapters of the Constitution and was to later take us through a series of various articles and challenge them through the various arguments that he took us through. He brought about and enlightened us on various conundra as far as the Constitution is concerned. He used several examples and looked at the representation of the people. He questioned efficiency versus just having constitutional governance. He looked at the roles of the Speaker. He looked at voting rights. He espoused on various articles and not least ended on Article 71, ex gratia and gratuity. He looked at some of the dispensation within the Superior Court of Judicature, and obviously also questioned some of the operations and operationalization of some of those articles. He additionally looked at some of the ghosts of the revolution that exists and pertain within our current 1992 Constitution, looked at the district assemblies and the efficiency of running a government by questioning whether we would rather prefer to continue to give monies to the district assemblies when there appears to be some questions that surround the utilization of such funds. Begs the question, does the current Constitution require a comprehensive review? Ladies and gentlemen, our guest speaker has made a case for the need for a multi-party, all-inclusive and comprehensive review of the 1992 Constitution, and actually advocates that the 2010-2011 Commission's report should serve as a resource to be able to conduct a comprehensive review. He concludes by saying that it's important that as a country we reflect on global trends, particularly questions the presidential governance versus the Westminster, and makes a case for future aspirations of Ghanaians. And on that note, I would like to say thank you so very much, the Honorable Osei Kyei-Mensah-Bonsu, and I'm sure that you're going to be asking your, did you say the Chief Whip, your wife, to accompany you? Because the Vice-Chancellor has a small token to present to you, and I'm going to invite your wife to join you to receive this token from the Vice-Chancellor. Mrs. Irene Osei Kyei-Mensah-Bonsu.
Thank you very much, Chairman. And thank you, everyone. I would want to acknowledge the presence of Professor Thomas Kwesi-Tieku, Professor of Political Science, University of Western Ontario, Canada. Thank you for joining us. Shall we please acknowledge the following announcements? Students should please remain in the hall to be served. Convocation and all other dignitaries will go to the Great Hall foyer for refreshment immediately after the program. We'll have a photograph session as well. Shall we please rise as I invite the Catholic chaplain for the closing prayer?
May I please beg your indulgence for prayer. Our help is in the name of the Lord who made heaven and earth. Dear Lord and Master, we are so much grateful to you for the gift of our lives. We thank you for our dear nation, Ghana. We thank you for our Constitution and how far it has served the needs of our dear nation. And we thank you for our leadership. We thank you in a very special way for our Honorable Speaker for this evening, who has enlightened us, giving us all the reasons why we need to amend or review our Constitution. We pray that his words will continue to resonate in our minds even as we go national with it, pressing on for this review to be a reality for us. We thank you for our university. We thank you for what you've used us to do and what you continue to use us to accomplish in the lives of many in our dear nation, Ghana. We thank you for our 70 years of existence, of global impact, and even a renewed focus to do more for our dear nation and for the entire world. We thank you for the planning committee, for our sponsors, and for all those who have worked behind the scenes to make this public structure a reality. Even as we depart from here, we entrust ourselves, our families, into your care. Be with us, bless us, protect, and direct us in all that we do. We also pray for traveling mercies to our destinations, and we pray that you dispel the darkness of this night, grant restful sleep to our bodies, renew us in our energies and strength, that we may continue to work to build our nation, Ghana. And may your blessings and peace and favors rest upon us, the Father, the Son, and the Holy Spirit. Amen.
Please remain standing for the recession of the chairman, speaker, and other dignitaries. All right, so we'll take the photograph here. Yeah, so please, the speaker and management of the university. Oh, there were videos. Maybe order photography. Yeah, order no more sharing.
Our first place.
Maybe. The next is Speaker